Hello everyone, welcome to Analog IAS. In this new video, we'll be discussing about the new topic called Panchayat extension to the scheduled areas. We know that Part 9 of the Indian Constitution deals with the Panchayati Raj institutions, and there is an exception in these articles that the 9th schedule is not applicable to the 5th and 6th scheduled areas and also to the union territories as well. If the Parliament seeks to deploy the provisions of Panchayati Raj institutions to the 5th scheduled areas, it needs to provide a different act for that purpose. Therefore, this is where the PESA comes into picture. Thus, the name of the act says that Panchayat extension to the scheduled areas. These provisions are applicable to all the 5th scheduled areas in about 10 states. Now we look into some of the important provisions. It states that the state legislation on the Panchayat in the scheduled areas should be in consonance with the customary laws, social and religious practices, and also the traditional management practices of the community resources. As we have known that in the 9th schedule, the main importance is given to the Gram Sabha. Hence, in PESA also, the Gram Sabha plays a very vital role, and the definition of the 9th schedule is similar to that of the PESA Act. One of the important role of the Gram Sabha is to approve the plan, program and projects of the social and economic development that are happening in the village level, and also it is responsible for the identification of the beneficiaries under the poverty alleviation and other programs. The village done by the village panchayat at each level has to obtain an approval certificate or the utilization of fund certificate from the Gram Sabha for enhancing the transparency and accountability of each panchayat. Now let us look into the reservation part in the PESA Act. It provides reservation for the scheduled tribes according to the population ratios in that area, and the important provision is that all the chairpersons of all the 3-tier panchayat level has to be reserved for the scheduled tribes. And if a scheduled tribe area has a less population and its representation in the village panchayat at all the 3 levels is less, then the state government may provide for the reservation at the level of intermediate level and also at the district level that shall not exceed maximum 1/10 of the total members of the panchayat. And the Gram Sabha at the panchayat and appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects. That is, if a mining company want to perform mining operations in the 5th scheduled areas, the approval of the Gram Sabha or the Gram Panchayat is a necessary tool without which they cannot proceed further. Now let us solve this question. Consider the following statements regarding the PESA Act of 1996. Part 9 of the Indian Constitution is applicable to 5th scheduled areas. Gram Sabha is endowed with the ownership of minor forest produce. The correct answer is B2 only. We know that the Part 9 is not applicable to the 5th scheduled areas. That is the reason PESA Act has been brought out by the Parliament in the year 1996 to deploy the Panchayati Raj institutions in the 5th scheduled areas. And Gram Sabha, as we know, is a very important pivotal role in the local self-government, where it is endowed with the minor forest produce under the PESA Act of 1996. Therefore, the correct answer is B, 2 only. Thank you.